Good evening, everyone, and welcome to our March 2022 monthly meeting of the Colorado Landlords Association, meeting online this evening. Unfortunately, because of the snow, I was really looking forward to a live meeting, first one in a long time, but hopefully next month the weather will cooperate and we'll go back to live meetings for the association. If this is your first time attending, my name is Bill Bronchick. I am the founder and president of the Colorado Landlords Association. We are a networking group for buy and hold real estate investors in Colorado. So basically our mission statement, I'll just read it with you. The Colorado Landlords Association, COLA, no relation to Coke, is a professional trade organization dedicated to landlords in Colorado, whether you're an experienced multifamily landlord, have a few duplexes, or thinking of even buying your first rental house or a multifamily. COLA is a great resource for education, information, networking, and support. And some of you have been around the group for a couple of years now. And some of you used to be members of the prior organization many years ago that I ran, called the Colorado Association of Real Estate Investors. So welcome new, welcome old, welcome young, welcome old. Welcome everybody. So we're going to talk tonight about the 13 essential lease clauses for landlords. Now, if you happen to have properties in other states, most of this is applicable. I'm just going to cite what the Colorado rules are as they are applicable to the particular clauses in question, but you can look those up with regard to what the rules are in the states where you have properties other than in Colorado. And many of you know the rules have changed fairly substantially over the last year or two in Colorado as a response to basically nothing. The legislature, the governor, the cities have all decided that landlords are the enemy, even though we couldn't collect rent for almost a year or sometimes even more with COVID. But we're at a very low vacancy rate right now. And there's probably some landlords that are not doing what they should be doing or doing things they shouldn't be doing. But for the most part, landlords, I think, are pretty fair in Colorado to their tenants. Notwithstanding, we have rules that we have to abide by, and Colorado is still a fairly pro-landlord state. When I moved here in 1993, it was a very pro-landlord state, particularly compared to where I came from, New York City, which is probably the worst place in the world to be a landlord in terms of the rules and regulations. So, the pendulum is swinging a little bit, and hopefully it won't swing anymore for us. All right, let's get into it. Clause 1, late fees. We all like to charge late fees, but we have to spell things out. So in order to charge a late fee, it must be disclosed in the lease specifically. You can't just charge a late fee if there's nothing in your lease about it. Most leases do contain it, even the generic office max form. But Colorado law, it limits your late fee to 5% or $50, whichever is greater. Some people were under the mistaken impression that it is the lesser, which is ridiculous because there aren't too many places for rent under $1,000 a month. But 5% of the monthly rent is what you can charge as a late fee, and you can only charge it, unfortunately, once, which is really disappointing. I used to charge $50 plus X dollars per day. That way I can get them to pay up quickly. So, it's unfortunate that they limited it to a one-time fee because whether they pay on the 10th or the 20th, it's the same late fee, which is unfortunate for us as landlords, but that is the rule. And the rule is also that you can't charge it until 7, not business days, but calendar days from when the rent is due. So if the rent is due on the 1st, you can't charge a late fee until the 8th. So it has to be 7 days late. Now, if you charge your rent such that rent is due on, let's say, the 20th of the month prior to the following month. So for example, April one rent is due on March 20th, and then late on the 2nd, there is a grace period there of more than 7 days. And that might, we'll see how judges interpret these things, because there hasn't been a lot of cases yet, but you may get away with that. Also, you may get away with having a discounted early payment of rent, which is probably going to be something would hold up better. Everybody knows that gas stations in some states charge a credit card fee one rate, cash another. So $21 for a gallon for, I'm kidding, $21 a gallon for cash, $22 a gallon for using a credit card. So the rules were in those states that you couldn't charge a premium for using a credit card, but it didn't prohibit you from giving a cash discount. So what I'm saying is, have a situation where rent is due on the 1st, late on the 8th, whatever, you could charge late fee, but when you set it up when you advertise it as, let's say, $1,500 a month, that's the discounted rate. If they pay after the 1st or after the 8th, whatever it is, then it's the quote regular rate of $1,600, let's say. So you're getting a cash discount for paying early instead of penalizing for paying late. Now, whether that's going to hold up in court, we'll see. I mean, it seemed to work fine with the credit card and cash discounts. We'll see how the judges interpret that. You can't just evict for late fees, which is unfortunate. So if someone pays late one month and doesn't include the late fee, then the following month just ignores that fact and pays the regular amount, you can't give a notice to quit for just the late fees that are due for the prior month or prior months. But you can require in your lease that all payments apply first to late fees and then to rent. So it should spell that on your lease, that every dollar I receive from you is first applied to late fees and penalties, then rent. So for example, if they pay on the 10th, which is late for 1 month, and they ignore the, let's say, $100 late fee, following month they pay on time, you send a notice that, okay, we applied $100 of what we received towards last month's late fee, you're still short for this month. Now, again, you can't evict for just late fees, so how are judges going to interpret what I just said? Typically, that was fair game for many, many years, not just in Colorado, but in just about every state. That was standard practice. But again, we'll see how the judges want to interpret the late fees. So just try to get creative. Don't gouge people. Operate within the statute. Read it again. If you're not sure, especially if you're outside of Colorado, meet with a landlord-tenant expert attorney and review your lease. And that's something that my law firm does for people in Colorado. Clause 2, joint and several liability. This is a legal concept that says if there are two parties to an agreement, the liability is both joint, meaning both parties are liable for the payment, and several. Several means liable for the whole amount. So if you have two tenants, let's say for more likely, for argument's sake, two buddies or two gals who are splitting a 2-bedroom that's $2,000 a month, and they're both tenants on the lease, the liability is not only joint, that both are liable, but several, that each is liable for the $2,000, not for the $1,000. Thus, if one moves out and says, I'm out of here, I'm not paying for this lease, both parties are still liable for $2,000 a month. That's how it should be read in the lease. The tenants are jointly and severally. So if they split up, a divorce, a disagreement, or someone moves out for whatever reason, then you want to have joint and several liability. If renters are not creditworthy, you may require a guarantor on the lease and have a separate guarantee agreement of someone. Now, who's that likely to be? A young person who you get their parents, especially in a rental situation where you're at a university. But note, you cannot discriminate by age or marital status. Thus, if you say, well, you're too young, you're otherwise credit worthy, you have a job, but you don't have enough experience in being a tenant, and that's a risk to me, so therefore I want a guarantee of your parents, that could be discriminatory by age. Or if you're saying you're not married, I typically, if you said something dumb like if you were a married couple, it would be different. That might be discrimination by marital status. In fact, that would definitely be discrimination by marital status, which you cannot do. Number 3, this is a really important one. The right to enter and or inspect the property. People ask me this all the time. My tenant won't let me in to inspect the property or show it to somebody, whether it be a contractor, prospective buyer, another future tenant, whatever, an appraiser. And the landlord asks me, can I go in anyway? And I said, what does your lease say? And they'll tell me it doesn't say anything. So that's just tough nuggies. Now, if there is an emergency issue involving the warranty of habitability. Habitability refers to things that makes the property habitable, like a leak in the roof, air conditioning, heating, water, electric, the major things that make a house habitable, which is required by landlords in every state. It's just whatever the definition of habitability is going to be different from state to state. But if it is a habitability emergency, you do have a right vis-a-vis what it says in the lease. But nonetheless, your lease should spell these things out. So you must have a right to enter and or inspect in the lease to do so. You can't just say, knock on the door, this is my monthly inspection because I want to. You have to have a right spelled out in the lease. Another way, which is how I used to do it before I had a property manager, is to have your handyman knock on the door and say, hey, I'm changing out the furnace filter for you and checking the batteries, replacing the batteries in the smoke detectors. And then they're your eyes and ears and report back to you. And that's just another way of getting around any inspection issues. So if you have a lease currently that doesn't have the right to inspect or enter, and you want to get your eyeballs because you suspect something going on, send your handyman in, knock on the door and say, hey, we're here to change the furnace filters or whatever, and get a peek. That's a good way to do it. The next clause, clause 4, an insurance requirement. Now, in multifamily, it's standard practice that you have to have renter's insurance. What does renter's insurance cover typically? Well, it covers losses of personal items to the tenant. So if there is a water leak in the building or a leak, someone leaves the window open or there's a theft, renter's insurance covers the tenant. It's not really a landlord problem. But when it comes to liability, though, from a guest, a trespasser, a visitor, you want your tenant to have insurance that names the landlord as an additional insured for liability. So there's 2 parts to an insurance policy. There's insurance for replacement as insurance for liability purposes to defend and indemnify the insured. On that portion of the policy, it is relevant to you as the landlord, and you should require the tenant to have a minimum amount of insurance, maybe $500,000 of liability coverage that names not only them as the insured in case they get sued, but you as the landlord as an additional insured. And the reason that's important is, let's say there's a frivolous lawsuit. Someone visits the house and trips on the slips on the ice out front. They're going to sue everybody, including you as the owner of the property. Now, even if it's your fault or not, it's going to cost you money to hire a lawyer to defend that and even get it dismissed if it's completely frivolous. But that costs a lot of money. So having an additional insurance requirement for the tenant's policy means their tenant insurance policy will cover you as the landlord for that defense. Now, you probably have your own insurance as a landlord for liability that would kick in too, but you may not have to make a claim under that policy and thus get your rates raised on you for an incident. So it's just an extra layer of protection, so you don't have to always go in your own policy. Number 5, this is one that always got me on single families, which was yard responsibility. And in fact, I've had property managers that I really got on them because I used to get notices from the city saying the grass is dying or it's overgrown and give me a violation notice. And it wasn't clear in the lease who was responsible for the yard. So you got to make it very clear on single family houses. You should require the tenants to maintain the yard and be very specific in the lease about what is required of them. Mowing, I meant weeding, watering, etc., trimming the bushes, weeding the flower beds. You have to make it very, very specific. So if the tenant, argues with you, you can go right to the lease and say, these are the list of things that you signed for responsibility. Number 6, guests and additional adults. So all adults, as a matter of practice, who are going to be on the lease or actually living in the building should be on the lease with joint and several liability, of course. If you do a practice of husband and wife, 1 application, and 2 unmarried people, 2 applications, you're discriminating based on marital status. So that's not good either. Nonetheless, if there's husband, wife, and friend, husband, wife, and cousin, husband, wife, and uncle, 2 friends, 3 friends, whatever, everybody, every adult fills out an application, pays an application fee, and is on the lease with joint and several liability. You cannot say X number of people can live in the unit. You can't say that, because what if they have more kids, or they don't have kids and then they have kids? It's discriminating based on the familial status, which is the number of kids or whether they have kids or not. So you can't do that. But you can say X number of adults. Now, what's an adult? That's someone who's 18. If, for example, let's say you rent to person A and B who are husband and wife, and they have a child, well, that's a third person. But husband has a child from a previous marriage that decided to move in with dad, and he's 13. Can you prohibit that? The answer is no, you cannot do that. But you can say it's limited to X number of adults. So if someone comes home from college and decides to move in with mom and dad when they're 22, you can require screening them. Okay, so cousin, an uncle, an adult child moves in, you can require a screening, an application, joint and several liability, and additional rent. Yes, you can charge additional for the additional adult. Okay, all right. Here we go. We're moving quickly. We have a question already in our chat right here. My insurance agent said no to additional insured, but to list myself as an additional interest, because with additional interest, I could sue the tenant. Does this make sense to you? I think you're getting it backwards. You're seeing my insurance agent say no to additional insured. Who? Are you the tenant or the landlord? Be clear there. I think what you're saying is you're the landlord and you want your tenant as an additional insured. That we're not doing. You want the tenant to have a policy naming you as the additional insured. So why don't you respond to that, and we'll come back to that question. Okay. Let's see. We're up to already number 7, pets. Pets. This is a big one. You can charge a pet deposit, and it can be all or partially non-refundable. So I might do a $500 pet deposit, depending on how many pets they have and the nature of them. You can discriminate based on the number of pets, the type of pets, and the size. They're not protected. okay, from discrimination. So if you say, for a Chihuahua, it's $100 fee, but for a Great Dane, it's a $400 fee, just because, a bigger dog, bigger chance of damage, or more dogs, more cats, or a weird animal. And by the way, other than dogs and cats, you can prohibit exotic animals, particularly if there's a prohibition in the city or county where you are. I know where my properties are, the city prohibits pit bulls. Now, I'm not going to get into whether or not pit bulls are nice dogs or not, because somebody's going to say, I have a pit bull, is the sweetest dog in the world. That's wonderful. But according to statistics, 60% of dog bite fatalities are from pit bulls. So I don't want to hear it. Nonetheless, putting that discussion aside, if the city says you can't have pit bulls, you can't allow a pit bull. It's as simple as that. You just can't rent to that family, or you can tell them no pit bull. Okay. You can charge a premium in rent for pets. So some people like to encourage pets, like, we're pet friendly, and then nail people for extra rent, for bringing in their best friend, which people are willing to pay, because a lot of places say no pets, or charge exorbitant pet deposits. But instead of doing that, or in addition to doing that, just charge extra rent for the pet. But this was probably coming. You cannot prohibit disability or emotional support animals. It's kind of a weird area of law, the emotional support thing. The assistance animals definitely violates the American with Disabilities Act and the Colorado Disability Act. So if someone needs a seeing eye dog or whatever, without a doubt, you can't discriminate based on that. Emotional support, I need my pet frog because he makes me feel better. There's really not a lot of law on this, so you have to kind of defer, unless it's like a prohibited animal, like a pit bull. So if they're emotional support animals, a pit bull, and the jurisdiction says no pit bulls, you can prohibit it. And if it's an exotic animal, and exotic animals are prohibited, or farm animals like a potbelly pig or something like that they need for emotional support, you could say, sorry, the jurisdiction doesn't allow that type of animal in this zoning. All right, so you can do that. You can, by the way, ask what the disability is and require proof of it. That's not discriminating, and that's not violating the American with Disabilities Act. And by the way, the American with Disabilities Act only requires that you make a reasonable accommodation. If someone in a one-bedroom apartment, 400 square feet, wants to bring their pet pony in for emotional support, that's ridiculous. That's not a reasonable accommodation. So, or if the dog bites people, barks all night, you don't have to accommodate that. So you could say in your lease, you can't charge extra, by the way. You can't charge extra for support animals, but you can put in the lease that a provision that said if it bites someone, attacks someone, and you may have to be specific and say there's a sheriff's report to prove it, because usually when there's a dog bite and someone goes to an emergency room, they report it to the sheriff. It's required in most jurisdictions. Or if the dog is barking all night or leaving little packages in the hallway all the time, at some point you can bounce someone with a support animal, but you got to be specific in your lease, and it's got to be reasonable. So back to the question about additional insurers on liability. You're a landlord requiring renter's insurance of $300,000. My insurance agent said to have tenant list me on his insurance as additional interest. This will create liability problem. I'm not showing what. No, your agent's wrong, or his insurance that he's representing has a problem, or they're calling it something different. An additional interest is an ownership interest, whether it be a leasehold, option, deed interest, mortgage interest, lien interest, whatever. An additional insured is someone who's protected in the case of liability. So I think we may be talking apples and oranges. Maybe the insurance company that your agent is dealing with, or if they deal with multiple stuff, your agent just may be wrong. So I'd call around. Notice of non-intent. This is a good one. This one I heard about recently because it's really important, I think. So most leases will expire without any required notice. So if you've got a 12-month lease in most states, definitely Colorado, you don't have to give any notice. If they're not out by the end, you don't have to give them notice that, by the way, in 1 month, your lease expires and you have to be out. It's not required. If they stay beyond and you don't accept rent, you can give them a notice to quit and then get possession. Now, as soon as you accept a payment, it becomes a month to month, and there's a different notice to terminate that month to month. But if you've got a lease that ends July 31st and August 1st, they're still in there, you could start, with the notice to quit and get them out. You don't have to give them a notice prior to that. It's not a bad idea, but the idea I was told, and I'm going to include it in my stuff now, is to require the tenant to give notice of their intent or non-intent to renew. And if they don't, you can charge a penalty for that out of their security deposit. That is something that I thought that was really creative. So if, let's say it's a 12-month lease and you want to know early whether this tenant intends to renew or not renew, you could require in the lease that at least 30 days prior to the expiration of the lease, the tenant must give their notice of non-intent to renew. If they don't, and they leave timely and leave it clean and everything, they still get dinged a penalty of $100 or something like that on their security deposit. You can't forfeit their whole security deposit. That would be unreasonable. A judge wouldn't allow it. But certainly if it's the lease says you have to give notice and you don't give notice, it's a contractual obligation that they're not abiding by, and $100 is certainly a reasonable penalty. Certainly a reasonable penalty. So, we all like to know whether our tenants intend to renew or non-renew. And as we all know, most tenants decide about 3 days before the lease is up, or they just don't say anything and they send a check and you take it. And now you've created a month-to-month tenancy, which renews every time you accept another payment. All right. So it's good clause to have. I heard this from someone else and I thought it was a brilliant idea. Number 9, a lease buyout clause. Now, this is interesting. Suppose the tenant leaves early, okay? You can hold a tenant to the full term of the lease. So if there's a 12-month lease or a 24-month lease, and they leave for whatever reason, good or bad or indifferent, it really doesn't matter. They're contractually bound to pay it. And if they leave after 6 months and you've got a year lease, they're liable for 6 more months of rent. They're liable, and then you can't charge them, sue them for all 6 months. You have to wait for the 6 months to expire before you can sue them for the 6 months. Now, here's the thing though. The landlord has a duty to mitigate their loss, which means you have to try reasonably, good faith to try to re-rent the property to somebody else. And if you do, let's say, re-rent it to someone else 2 months later, then you can hold this tenant liable for 2 months worth of rent. Okay, you could sue them in small claims or whatever. Or if it's a month and you haven't given the security deposit back yet, you could take it out of their security deposit. However, you should consider having a buyout clause with an agreed upon fee. So it reads sort of like this. In the event the tenant breaches the lease by leaving early, terminating early, or abandoning the property and not paying them, the required payments every month when due, then we have what's called a liquidated damages provision. Now, this is pretty standard in contracts. When you put up earnest money and it says, well, if the buyer doesn't close, the seller's damages are hard to determine, so we'll agree up front to liquidate. That means identify a sum that the seller was damaged, which is the earnest money deposit. Now, you can have, if you only have a month's worth of security deposit or less, that's not going to be enough if the tenant leaves early. So you could say that if the tenant wants to terminate early, they may. And in that case, you agree that the liquidated damages for such a termination is X dollars or X months of rent. And typically in apartment buildings, they do 2.5 months, sometimes more, sometimes less, as a termination fee. So you can basically give them an option to buy out. Otherwise, if they just leave, you got to chase after them for the money. But if it's in there like, okay, I'm breaking my lease, it's kind of fair to the landlord, I agreed to this up front, I'll pay it. Or you could even negotiate it down to something less if they don't have it. But just, it gives you the ability to collect money for your damages without having to chase after someone months or years later in small claims court. It's a good idea. All right, moving right along. If you have questions as we go, feel free to put it in the chat or in the Q&A section. Okay. Number 10, security deposit clarity. Security deposit clarity. So many landlords just have a small provision in their lease that says the tenant has paid X dollars as security for the performance of the lease. And that's all it says. That's like gross malpractice. Now, first of all, in terms of returning deposits, Colorado law requires that the security deposit be returned within 30 days of the expiration of the lease. However, your lease agreement can say that the landlord has up to 60 days to return it. Otherwise, if it doesn't say anything, it has to be 30 days. You must, without exception, give the tenant written notice in detail if you plan on withholding something, and specifying what you're withholding, why you're withholding, and justify it. It might be like a carpet cleaning receipt or a bid from a contractor for something they broke, but be as specific as possible in writing to the tenant's last known address. Now, this is a tough one because sometimes if they leave early and you're trying to keep the security deposit and you don't know where to mail it to, you just mail it to the unit, and then hopefully if they don't have a mail forwarding thing, well, that's their problem. Most people have email these days, so you know the statute says mail, not email. So do the mail, and then as a courtesy to make sure they get it, I would just email them a copy. Don't just email if the statute in your state says mail or certified mail or registered mail. Be specific about it, okay? So give the tenant written notice in detail of what and why you're withholding. Now here's the issue. If, let's say it just says what I said earlier, we're holding a security deposit of X dollars for performance. Well, then the law is 30 days. So if you don't give the tenant notice within the 30 days, you must give it back. Even if they owe you money, you must give it back. If you don't give it back, they could sue you for the money ×3 treble damages plus attorney's fees, even if you are right and they are wrong. It's the notice requirement, not who's right and who's wrong. So just, they're two different issues. If it's 30 days has come up and you went, whoops, forgot to give notice, give them the money back and then go sue them in small claims for the actual amount, which could be 50 times that. But if you don't give written notice within the statute, you must give it back. Okay, that's very, very important. You should specify in your lease, or even having a separate security deposit agreement, which I like to do, what the landlord can take out of the deposit. Because if you don't, the only thing you can do is what the statute allows, okay? So, for example, you could say that the landlord may, within their discretion, take money out of your security deposit for rent if you're more than X days late. And then the tenant has an obligation to restore that within X number of days, otherwise there's a penalty. So you could be that specific, and you should about it. You could say that it's a security deposit also in the landlord's discretion for any damages, for any things left behind, for any dirt in the carpet or stains or tears or whatever. Be very specific about what you can do as the landlord with that security deposit. And consider, some people are doing this, what's called all or part of the deposit as what they call a rent lock fee. So instead of collecting a deposit, which requires all this accounting and notices and returning and blah, blah, blah. And the reality is most people end up skipping and you keep their security deposit all or part of it anyway. So what some landlords are doing is they're collecting in lieu of a security deposit, either all or partial, of charging what's called a rent lock fee. So if you're charging $2,000 a month, they can pay $1,000 as a rent lock fee to guarantee that if they want to renew, they renew it at the same $2,000 instead of $2,200. Now, $2,200 is $200 more. 200 times 12 is 2,400. So really, to the tenant, it's a bargain to pay $1,000 up front to avoid paying $2,400 next year. Okay, and they're willing to pay it unless they just really not sure if they're going to stay more than a year. And the reality is most people don't stay more than a year. But so you win on that one. You're allowed to collect it. You don't have to escrow it. You don't have to give notice. It's not a security deposit. Now you might split it up. You might say, okay, if rent is $2,000, you give $1,000 deposit, which is refundable as long as you behave yourself. And another $1,000 is a rent lock fee, which is non-refundable. In some ways that's good, in some ways that's bad. The good is you get to keep it, you don't have to worry about it, but the bad news is you only have $1,000 to hold over their head at the end of the lease. Okay. Matt asked, this is an interesting question. If the tenant gives you written approval for you to keep the deposit due to non-performance, does that cover you? That's a good question. So what you're saying is you get into a dispute before the lease is over. Let's say, I think the scenario you're talking about is it's the last month and the tenant says, well, just keep my deposit for the last month's rent. Well, first of all, the answer is generally no, because then you have nothing to hold over their head for damages. But if they damage the place and you've done a walkthrough, let's say, 3 days prior to the expiration of the lease, and the tenant agrees in writing that yeah, I screwed up and you can keep my deposit, then you wouldn't have to give it back. You wouldn't have to give it back, but you should make that very clear, not just keep my deposit for the damages. You should still identify an agreement in which the tenant acknowledges how they breached the lease and authorizes you to keep it and waives any notice, for keeping it thereafter. I can't say I'm 100% sure a judge would allow that, but I'd say I'm 99% confident. I'm 99% confident if you're very specific in that agreement. Okay, good question. Okay, clause. And by the way, what you can't do, however, is say in your lease that a tenant waives notice of any requirement under the law for security deposit after the lease is over. You can't do that. But if the tenant is in breach, they acknowledge they're in breach, they say you can keep it. I'm taking it all back. If you do a walkthrough like 3 days before the end of the lease and there's all kinds of stuff and you come to an agreement, I would still, before the lease is over, because the statute says within 30 days up to 60, if it says in the lease after the expiration of the lease, nothing prohibits you from giving them notice of keeping part of their deposit before the lease is over. So if 3 days prior, you do a walkthrough and they acknowledge, yeah, I screwed up, you get to keep all of my deposit or part of my deposit, I would still mail them the notice and email it to them and hand it to them, because that satisfies it, and then have them acknowledge that they received it and agree to let you keep the security deposit. So at least they're acknowledging receipt of the notice, and they're agreeing to waive the security deposit in case you go to court. So that's a good one. All right. Wait a minute. I think I skipped 11. You're getting gypped of one. I'm going to have to think of one before we're done. Number 12, violation penalties. Oh, this is interesting. Mike asks, can a separate utility deposit be required to ensure they pay the utilities? Well, the only utilities that you have to worry about really is utilities that are public, like water and sewer, that create a lien on the property if they don't pay it. Things like electric and gas and cable and internet, those things don't become liens on the property. So it's a contractual obligation between the tenant and the provider. Can you require a separate utility deposit? Sure. Or you could just say, that within the landlord's discretion, if I get a notice that you haven't paid the water bill in 2 months, I could take it out of your security deposit and require you to replenish it. So, I think it's redundant. I would just put the latter. I know someone asked, what was clause 11? It was an error in accounting when I did this PowerPoint. So I'll think of something. Maybe somebody asks a question, and that'll be the bonus one, the fill in 11. Number 12, violation penalties. So let's say you have an HOA, whether it's a condo, a townhome, or it's a house within a homeowners association, and there's a violation notice, and the HOA charges a fee for a violation or second violation. Usually the first one's just a notice, second one's a fine. You can charge that to the tenant. Yes, you can. Same thing with code enforcement notices. You can charge to the tenant for repeated violations. So if you get dinged, they get dinged. Now, the other question is, if you get a warning, can you charge the tenant a fee for violating even though you weren't feed? And I think the answer is yes, you can. You can get a violation notice, like a violation penalty in the lease. It says, first violation X dollars, even though the HOA gave you just a warning. I think you're in your right, within your rights to do that. Finally, clause 13, until we come back to 11, the use of the premises. I would be very specific. Residential use only. Now, what about business use? People do work from home, COVID and everything, and now everyone's telecommuting. Do we want to limit business use? Now, first of all, can you limit business use? The answer is clearly yes. Even if their their employer says, you must work from home 3 days a week, and here's a laptop, you could say, no go, you can't work from home. Now, that's silly, because why do you really care if they sit in a laptop and stare at a Zoom all day like this? But other business use, like having people come to their house for massages or something like that, or other services, whatever, you can, because it could create a problem with zoning, with the HOA, with parking and stuff like that, neighbors complaining. So yes, you can limit to residential use only. Something that I would put in the lease to say, you can't mass storage stuff. I've heard many stories, it hasn't happened to me that much, but of other landlords where someone rented a house and then moved out and lived somewhere else and just used the house as their self-storage because it was just a place to keep all their stuff. So you can have a clause that says you can't mass, collect stuff and become like a hoarder, or you could limit how much they can store in the garage or the basement or the bedrooms or whatever. And, that's going to be a judgment call, obviously, what is excessive storage, but having some sort of clause that allows you to enforce that is better than not. No smoking of any kind, perfectly legal. Obviously cigarettes, no smoking in or out of the house, because you don't want people with cigarette butts on the lawn or whatever, or starting a fire in a dry area. So you get to marijuana. That's the next thing, marijuana policies, recreational and medical, two different issues. Medical might be covered partly under the American with Disabilities Act because it is a medicine. as legalized prescribed medicine. For recreational, you can completely prohibit it. You can say there is no smoking of any kind, of anything. So they could have a medical prescription for marijuana, and you could say you can't smoke it on the premises, in or out. That is legal because they have another option, which is to walk down the block and smoke it or take an edible. So it is okay to say no smoking of any kind. What about storage of it? Now, if they have a medical prescription, you can't prohibit them from storing, small amounts in the place. That's okay. Now we get to growing. Growing can be prohibited. Yes, you can prohibit growing. I know the law does allow for medical use a certain number of plants that you're allowed to, I don't remember what it is, but there's a certain number of plants you can grow at home in a residential neighborhood because it's cheaper, if you're medical. So the question is, can you require or prohibit rather someone with a medical prescription from growing, even though they have a right to grow because it's cheaper, and they complain, well, it's too expensive to buy it, I need to grow it? Yes, you can, because this falls under, again, the American with Disabilities Act, because it's a disability, a medical use. In that regard, you only have to make reasonable accommodations. If someone wants to grow, it could use extra water if you're paying for the water. It could cause smell problems. You can get humidity issues and get into the carpet or the wall, the drywall. It is an unreasonable accommodation. And it all depends on how many, right? If they have a couple of little plants, what's the big deal? But you go into the garage and they've got they want to upgrade the electric service so they can put in 40 lights and water, have an irrigation system in the house, and no dice. You should specify fines for disturbing other tenants and what it includes, especially in multi-units. Usually there's a non-disturbance clause in almost every lease that you can't disturb other tenants' use of the premises, but you should have a specific fine thing, like you get a notice of violation that someone complained about your stereo too loud. You get a second notice, and maybe you want to come out with, or your manager come out with a decibel meter. You can get an app for your phone to do that. And if it's above a certain decibels, like 100 decibels, then they get a fine for that. So instead of just saying you can't disturb other tenants, say, well, if you do the following, the fine is X, or you get one warning and then there's a fine, and second fine is Y. So you can be very clear about that. Other use, parking policies, particularly in HOA and apartments. You could say, hey, no parking cars on the street, no more than 2 cars in the driveway, no RV storage, no boats for more than a certain number of days, or RVs for a certain number of days, no trailers. Be specific, especially in an HOA that might prohibit it. So whatever the HOA rules are, at a minimum, that should be your rules. You might even get stricter than that. You can do that. That is legal for you to do so. Okay. All right. I think that's all I had for the 13. There's my contact info for the Colorado Landlords Association is colandlords.com, where you can check out upcoming meetings, articles, join membership. And membership, it doesn't include recordings of this type, so that these will be available in a storage on the member section of the website for members of the Colorado Landlords Association. And as well, we have recorded just about every one of our live meetings too, and they will be available. We're a little behind because my IT guy is from Ukraine and he's temporarily indisposed. So we're a little behind on that. So we'll catch it up over the next few months with someone else. We also plan on recording upcoming meetings, live meetings as well. And we will, when we have live meetings, here's the deal. No streaming, because I know church pastors who have been bitching about this. During COVID, it was a blessing to have the ability to Zoom, so people sit on the couch with their iPads and their laptops and go, praise Jesus. Fine. But then when they're allowed to open up, the attendance dropped dramatically. And first they thought, well, maybe people were afraid of COVID. No, just people got lazy and sat their butts on the couch and said, well, I'm going to church today on my couch. No. And they realized it was a bad idea. So a lot of them are cutting off the Zoom streaming for people local. So since we are a local association, we're going to cut off the streaming for the live meetings. We will record them and make them available for members, but there'll be no more streaming when we have live meetings. If you want to contact me for legal services in regard to lease, real estate, corporate entities, estate planning, and what's the fourth thing I do? Setting up self-directed retirement plans to buy real estate, Bill at bronchicklaw.com, Bill at bronchicklaw.com. So someone in the chat, give me a 13th topic for a lease thing. Maybe this is the grab bag here. Everybody share something that I haven't mentioned that might be a good lease clause to share with everybody else. And there's no competition, so don't worry about it. You're doing some people a favor and you're not providing competition by sharing that. So why don't we give that a few minutes for someone to pop something in the Q&A there? All right, I'm looking for a clause 11 here. We have almost 20 people on the Zoom here, so somebody share or come up with an idea for an 11th. There we go. Thank you, Susan. Can you have a clause about abandonment and not having to evict and move all their stuff out? That's a good one, Susan. The answer is no. You could say, no, here we go. Let me clarify that. You could say if the property's been abandoned, the landlord has the right to retake it. And you don't even have to say that. That's just standard practice. That's the law. But abandonment is not clear all the time. So if they leave anything, if they leave one couch behind and it's pretty clear that they abandoned the couch, then you can go in and change the locks without an eviction. But you can't say if you're, not in the property for more than 30 days, we'll consider it abandoned and then we'll change the locks. I don't think you're going to get away with that without having to do an eviction. Okay. Let's see. This is an interesting one. A clause that requires the tenant to report needed repairs to the landlord. I think such a clause, Angel or Angel, I'm not sure how to pronounce that, would be futile because if they don't do it, then what? What are you going to do? Find them? And how are you going to find them? I guess you could say, failure to report a leak in the roof causes a fine, or I can hold you liable for damages. I suppose you could if it wasn't known to the landlord. I guess you could do that, but the reality is they won't do it. Now, around that issue, let me say that a lot of landlords think that tenants who don't complain are good tenants, and then they don't raise their rent for being good tenants. That is stupidity, because what happens is if you don't raise their rent, they're not going to complain. They're afraid to complain because they'll think that you're going to raise their rent for being a pain in the neck. So you want to know about certain things. Certain things like, clogged toilet, go call a plumber, or, the screen door doesn't work, no big deal. But if there's a leak, a water leak or something, or, or the furnace is spitting out carbon monoxide, you want to know about these things. You want to know about these things. So you bring up a good point here. Can you have a clause that requires the tenant to report needed repairs? Sure, you can. The question is, are they going to abide by that? I don't know. Could you say in the lease that failure to report something that later leads to damages is the responsibility of the tenant? Contractually hold them responsible for negligence? I guess you could. I don't know what a judge would say to that in court, whether you can do that. Contractually, can you contractually assume the risk or contractually admit negligence? That's a good one. You can hear something from you rarely hear from a lawyer, which is that I really don't know. That's a good question. That's an excellent question. Right. So you mentioned here, tenants are required at least to return the premises the same condition as they received it, minus normal wear and tear. That was the one. That was the one I missed. Okay. So a lease should say, and it usually even the cheapest, worst leases will say that the tenant is responsible for anything beyond normal wear and tear. Okay. Define normal wear and tear in the lease. Define it. Okay. Now you can't be unreasonable about it and say, well, the carpet is not as, bright and shiny and it doesn't have much sheen or isn't as soft as it was. You can't be that ridiculous. But you can say that holes larger or stains larger than a dollar bill, let's say, in the carpet is not normal wear and tear. You can be specific about it as long as you're reasonable about it, and and a judge would find that reasonable. You can't say any stain larger than that in the nickel. I mean, that'd be unreasonable. Even car dealers, when you return leases, have like the dent has to be bigger than a dollar bill, or the scratch has to be bigger than a dollar bill. Holes in the carpet larger than 3 inches requires a fine of X. Or withholding of your security deposit of X. So you can define certain things that you consider as a landlord that they contractually agree are not ordinary wear and tear. So that's a good point. Thank you for bringing that up. There was my number 11. Luke asks, is there a clause that would cover domestic abuse and cops showing up repeatedly? I don't think so. Not the cops showing up. But you can say if someone is, especially in a multi-unit, in a single family, it's like kind of like not your business. So if husband and wife rent the place and the cops show up repeatedly because the husband gets drunk and yells or beats his wife or abuses his wife, that's sad. But I don't see that as a reason to terminate their lease or fine them for that matter. Now, in a multifamily situation, if someone is convicted of a felony violent crime, that could be grounds for terminating the lease of a violent felony. Now, unfortunately, our federal government doesn't seem to agree that's a reason to evict people from this country most of the time, but that's a whole other issue. But it would have to be very specific along those lines, like a felony conviction for a violent act, and maybe be very specific about what the violent act is, assault, rape, whatever it is. And I don't know if it's worth going into in the lease, because the reality is if they're convicted, more than likely they're going to jail if it's a felony. Well, it's not always true. Maybe the first time offense they get probation, but the reality is the time, Luke, the amount of time that it takes for that to get through the justice system will be beyond your lease anyway. You just don't renew them. Okay. These are all really good questions. Okay, so we got time for a few more questions, and then we will wrap up. Our live meetings are usually a little longer because we have a little more networking and kibitzing, so to speak, as my grandmother would say, Yiddish word. or talking with our vendors, which I would also give a shout out to on our website at colandlords.com, our recommended vendors, our business vendors, many of them on the website, and at the live meetings, they will, when we get back to that, hopefully soon, they will have vendor booths and you can meet and talk to them face to face. Mortgage companies, lenders, insurance, so forth. All right, I guess that about does it. Thank you for joining us. And if this is your first time, make sure you visit our website at colandlords.com. And we will have this recording up on the members section. I might just be a nice guy and just post this on my YouTube page, just because it's kind of like the last Zoom we're going to do until next winter. So check my YouTube page at youtube.com/my last name Bronchick, and I'll post it up there in a day or two. All right. Thank you, everyone. If you're driving out there the next day in Colorado, be safe. We're supposed to get a lot of snow, and God bless.